But now I do want to move on to our next segment. This is group chat, because I don't know, we're very creative.
We're not doing that right now.
We've not been chatting.
We're not. We have the best names, guys. The best words here. Only the finest words to describe our segments. So I want to get all of your takes and do a little bit of a deeper dive on one particular story. And I think this is, a really complex one, but a really interesting one. And so I guess I should start at the beginning. I'm rambling a little bit. You're probably all aware at this point that earlier in the year, there was some hubbub about these algorithms and software used to determine prison sentences and how there might be racial bias built into these algorithms. One man went to court to try and challenge this as being unconstitutional and a violation of his due process. His name is Eric Loomis. He was sentenced to 6 years. I forget for what. I don't have it directly in front of me. But he took it to court, and the Wisconsin State Supreme Court ruled against him. They basically said that, there were other independent factors that impacted his sentencing, and it wasn't relying solely on the algorithm, and denied him access to the source code for this software. So, I guess I'll start really broadly and, on a very basic level. Like, what do you think of this decision? Like, is this actually a violation of his due process that some proprietary secret algorithm, even if in a small part, determined how long this man spends in jail? Dana?
I'm not totally comfortable with it. I'm generally excited by the growth of artificial intelligence, but it's weird to think someone's life is at stake here and hangs in the balance. But I also don't know if I'm totally comfortable with the status quo, and I can't say that we always get fair sentences when a human judge is at the helm. So I don't know what would be a satisfactory solution here.
Devindra?
I'm kind of in the same place. I think we do need to hear more about how Compass works and any other algorithm that people are using. So that transparency would be great. It's like your math teacher. You want to see how it does the work. But yeah, right now humans, they can be biased, and you don't know anything about how they work or how they're thinking or what their personal beliefs are. And that leads to judges, having a lot of sentencing that people would consider unfair.
It was a human judge who gave that Stanford rapist a really lenient sentence. That was not a bot or a computer. That was a human. Humans are not great.
Cherlynn, what do you think?
Basically, to be the contrarian here, I don't think it violates the due process, because it's just, like you guys have been saying, it is the human judge that's supposed to evaluate all this information that he or she has and to make the decision. So it's just another data point that they can refer to. And now that it's full-blown and everyone knows about these biases baked into the algorithms, these judges should be more aware, hopefully. So it's all about education right now.
Okay,
right?
well, so since you're going to be the contrarian here, I want to ask you, what should happen with software there? Like, what obligation do these companies have in terms of code and software if it's used by the government and it has a direct impact on the citizenry, even if it's theoretically proprietary?
I think, like you guys said, transparency is very important. If it's being used to determine a person's sentence, yes, it should be opened up for public analysis to see if, again, the bias is in place. There's always going to be biases. There's no way to avoid it, because humans are the ones that make these algorithms, these software programs. So we're going to just have to open it up for everyone to comment and say, hey, this thing is a bug, or hey, this thing is not right. It's not right that this thing is saying, oh, black people are more likely to reoffend, and then give them a longer sentence. So I believe the software should be made open.
Would you feel more comfortable if the software suggested, instead of a specific sentence, a range of appropriate sentence times?
I'm not completely familiar with what Compass recommends. So yes, that's a range is way better.
Yeah, I should be clear. At least I don't, and I don't know if you do, Devindra. No. I don't know how it spits out those recommendations for sentencing. It might be a range of years. It might be a very specific thing. But one of the things that sort of struck me as interesting about this is there was there was a couple of fairly similar cases, I think at least similar in, theoretical ways. There's some details here that are a little bit different, which I think changes the story a bit. But there was a bunch of cases in 2005 in Florida around breathalyzers and similar ones in Minnesota around breathalyzers, the specific model of which is the Intoxilyzer 5000EN.
Okay.
Great name.
So it is an amazing name. But this is, it's one of the most used breathalyzers in the country. And I think it was something like 150 different people challenged to open up the source code to the device in Florida. And people challenged it in Minnesota as well. And they all won. And specifically in the 2000 case in Minnesota, the attorney for the plaintiff, Dale Lee Underdahl, I hope I'm pronouncing that right, made this point stating that, basically without getting a hold of the source code and seeing how it works, there's no way to know what's going on. He said, for all we know, it's a random number generator. And when the courts found in favor of him, they basically said that at the end of the day, and this is one of the things that's kind of specific to it, and I don't know, we have to get some more details about the Wisconsin case to clarify this, but because of the way the contract was structured in the Minnesota case, and it was the same thing in the Florida case, ultimately what the courts decided was that once the state started using that device and that software to do breathalyzer tests, that code became the property of the state and was no longer the proprietary code of the company that makes the breathalyzer, CMI. So, I mean, I guess the thing here is that, this Wisconsin decision kind of flies directly in the face of that, saying that, no, this is proprietary information, this is proprietary code, and because it's just one factor in a million, they're not obligated to share it with you. But what do you think of that, Dana? Like, is there an obligation to be completely transparent about the way technology works at a governmental level?
It sounds like at some point along the line, an intellectual property lawyer reared his head.
Mm-hmm. Yeah.
I don't know the specifics, but this smacks a little bit of some patent trolling at some point. I think. Yeah, I mean, I see where the company would want to protect its secret sauce, so to speak, but I would rather it be transparent.
I mean, I feel like there's got to be some obligation. Like, as a country, we at least pay lip service to the idea of being transparent, especially at the governmental level. Like, and if we're hiding behind, proprietary algorithms, no matter how they're used, whether that's determining sentencing or figuring out whether or not you're drunk, doesn't that kind of fly in the face of that ideal?
I don't know if this is a perfect analogy, but when I do a credit score, I see a breakdown of why I have the score I have. And is that not something that can affect how you're perceived? That affects your life, your credit score, right? So let's use that as an example. You would see in the report that you were bumped a few points because of late payments or the percentage of your available credit that you were using. That affects my life, the credit score that I have and the opportunities that I have, and that is a rating about me. I'm glad that it is transparent and that I can see why I have the score I have. I think if I were accused of a crime or convicted of a crime even, I would also want to see this.
Yeah.
I believe, I'm not sure again how Compass works, but I think they do explain a little bit about, why, because this person has committed a crime before. That's why we gave this larger range of years. But I think the patent troll thing that you brought up, there's a way for the government to work around this. It could be yes, open up your patented algorithm and we'll guarantee you that no competitors can steal this code from you. We're just using it for the sake of transparency and to be clear about how we're doling out these sentences. I think that the government can work out the details with Northpoint, the company behind Compass.
So would it simplify things if just at a governmental level we just basically required that everybody use open source software?
That would fix a lot of things.
Open source would be great, yeah.
And I mean, there's people who make arguments against the use of open source. They would say things like, because it's out there that you can hack it or whatever. But we've kind of learned that that's crap, right?
Yeah.
I mean, Tay. I mean, people can be really crap on the internet, so I kind of see the point in that. As long as there are steps in place to prevent trolls from going in and screwing up the open source code.
Well, but I mean, the code is implemented on an individual basis. It's not like you're talking about building a giant online AI that's
Right.
going to sentence people to jail.
Not yet, Terrence.
Not yet. Skynet
Not
is
yet.
coming, everybody.
Oh.
But I mean, you're talking about using tools that are available for people to look at the code, change the code as necessary, and would have to be transparent about what those changes are. Because I think, I don't have this in my notes, but one of the other arguments that was made about in the breathalyzer case was basically that while this software had to go through a rigorous approval process and a rigorous testing process to be implemented, basically after that there was no requirements for approving and testing the patches in the same way as it was when it was launched the first time. So that meant that any changes that were made were basically like nobody knew what was going on. So, I mean, the other thing though is this is far from over, right?
No. Yeah.
I mean, where do we see this going? Is this?
Well, IBM's Watson is across the street, so I'm sure we'll see some interesting recommendations for sentencing with those sorts of things.
You think this is going to make it all the way to the Supreme Court? Is this going higher?
I think it could.
Yeah.
I think more importantly, it should.
I tend to agree
Which
with
is,
you.
It's a little bit scary only because I don't feel that the current court has always demonstrated a thorough understanding of modern technology in cases related to tech. So that concerns me a bit. And I say that in a very nonpartisan way. I think whatever side of the aisle you fall on, we can agree that we want a Supreme Court that
Understands how technology
understands
works.
the tech they're ruling on. Yeah.
I mean, I think it's safe to say, again, in a very nonpartisan way, that our government does not get technology in a very basic way at most levels. But
What was that case? I'm blanking on the name that involved getting access to TV stations. What is the company whose name is escaping me?
I know what you're talking about.
I actually have no idea.
I have no idea either.
Aereo.
The area
Area,
ruling.
okay.
My impression of that, for instance, was that the justices ruling on it didn't totally get it.
Yeah,
Remember that?
no, for sure. Yeah.
It did reflect I think, a fundamental misunderstanding of the case and the technology involved. It was a very outdated sort of view. But that is another very long conversation that we will have to save for another time. Thank you, everybody, for tuning in. Again, this is the Engadget podcast. We thank you for watching, and we will be back next week. Make sure to tune in then.